Today we begin in the middle of a moment thousands of visa applicants never expected to face. A fee increase that immigration attorneys had warned against, that advocacy groups had challenged in public forums, and that USCIS quietly confirmed with barely 48 hours' notice. A sudden email notification. A bright screen showing numbers that don't make sense. An updated fee schedule asking for payments that sound reasonable on paper, but aren't. This announcement didn't unfold over weeks of public comment. It unfolded in 72 hours. 72 hours that could drain your savings before your work permit arrives. 72 hours that could force you to choose between premium processing and rent money. 72 hours that could push your case into standard processing limbo for 8 months or more. One wrong calculation here, and you could be watching your job offer expire while your EAD sits in a processing queue. What USCIS did crossed a line that immigrants' rights groups hoped would hold. And when that line broke, immigration attorneys did not hesitate. They responded with legal scrutiny, public pressure, and coordinated advocacy efforts. Most people panic in this moment. They make the same mistake. They fall straight into the trap of paying without understanding what they're actually entitled to. But today, you're going to do something different. For 3 weeks now, there had been whispers. Not from official USCIS announcements, not from Federal Register postings, just whispers from legal listservs and immigration attorney networks, that USCIS was preparing something financially significant. USCIS has been under budget pressure, yes, but also increasingly aggressive in that approach. Their actions followed a predictable cycle, a revenue-driven cycle, almost a desperation cycle. But what triggered concern in immigration law offices nationwide this February was that the pattern suddenly went silent. No leaked draft rules, no stakeholder engagement sessions, no advance notice in trade publications. Experts who monitor USCIS fee structures recognize the indicators. The sudden pause in routine communications, the unusual Friday afternoon posting schedules, the lack of advance Federal Register notice, the sudden radio silence from public affairs offices. And when USCIS goes quiet about fees, something expensive is coming. Early February 28th, immigration attorney networks detected what they described as preliminary Federal Register language, including fee structure changes not seen in over 18 months. These are actions USCIS only takes when signaling something specific, a major revenue shortfall they need to cover immediately, a political directive to become self-sustaining without congressional appropriations, or a strategic move to slow down certain application categories by making them financially prohibitive. Observers weren't sure which one applied, or whether all three were happening at once. But one thing was clear. USCIS was changing its pricing strategy without the usual advance warning period. And when that happens without explanation, immigration attorneys pay attention, because their clients pay the price. The premium processing fee increase announced by USCIS on March 1st was not routine. It was not adjusted for inflation alone. It was substantial. Legal analysis after legal analysis described the move as financially burdensome, procedurally rushed, and most importantly, implemented without the 60-day advance notice period that previous administrations had typically provided for major fee changes. But strategy only works if applicants don't have alternatives. Many do not. The reaction from the immigration law community was among the swiftest and most coordinated seen in recent USCIS policy disputes. Today, multiple legal organizations confirmed that immigration advocacy groups launched coordinated responses targeting the fee increase implementation, including public comment campaigns that had recently been mobilized for what analysts believe was preparation for exactly this kind of sudden policy shift. They acted before USCIS could finalize the effective date. They targeted the lack of proper notice period. They targeted the fee calculation methodology that wasn't clearly justified in public documents. They targeted the exemption structure connected to fee waiver eligibility requirements. This wasn't symbolic legal posturing. It was actionable advocacy with real procedural grounds. And that's what made the attorney warnings so urgent. The new premium processing fees represent increases ranging from 15% to over 30%, depending on the form category. For I-129 petitions covering H-1B workers, the premium processing fee jumped from $2,500 to $2,805. For I-140 immigrant petitions, the increase went from $2,500 to $2,805 as well. But the most significant impact hits employment authorization applications. I-765 forms that previously had no premium processing option at all now have one, priced at $1,500 for a process that promises 30-day adjudication instead of the current 4 to 8-month standard processing time. This creates a two-tier system. Those who can afford premium fees get their work permits in weeks. Those who cannot afford it wait in processing backlogs that have grown to historic lengths. USCIS justified the increases by citing operational costs. Processing centers require staffing. Technology systems need upgrades. Background check systems demand resources. But immigration attorneys immediately pointed out the missing piece in that justification. USCIS already collects standard filing fees that are supposed to cover basic processing. Premium processing was always marketed as an optional expedite service, not a requirement for reasonable processing times. The problem is that standard processing times have deteriorated so badly that premium processing is no longer truly optional for many applicants. If your job offer expires in 90 days and standard EAD processing takes 180 days, you have no real choice. You must pay the premium fee or lose the opportunity. That's not an optional service. That's a mandatory fee disguised as optional. And that distinction matters legally. Because mandatory fees require different justification and different congressional oversight than optional services. The timing of this announcement also raised questions. March 1st implementation means applicants who filed cases in late February under the old fee structure might receive requests for additional fees before their cases are adjudicated. USCIS has not clearly explained whether pending cases filed before March 1st will be grandfathered under old fee schedules, or whether applicants will receive notices demanding the fee difference. That ambiguity creates chaos. Applicants don't know whether to expect additional payment requests. Attorneys don't know how to advise clients on budgeting. Employers don't know how to structure their immigration cost projections. The lack of clarity is not accidental. It's a pattern USCIS has followed before. Announce the policy change. Implement it quickly. Clarify the details later through individual case processing rather than clear public guidance. This approach minimizes organized opposition. By the time applicants and attorneys figure out exactly how the new policy works in practice, the implementation is already complete, and challenging it becomes much harder. Immigration advocacy organizations responded by demanding immediate answers to specific questions. Will pending applications be subject to the new fees? Will USCIS provide fee waivers for applicants facing financial hardship? Will there be a phased implementation period to allow applicants time to prepare? USCIS has not provided clear answers to any of these questions as of this recording. The broader context makes this fee increase even more concerning. USCIS processing times have been growing longer, not shorter. Despite collecting billions in filing fees annually, the agency has struggled to reduce backlogs across most application categories. Adding higher premium processing fees while standard processing times continue deteriorating creates a perverse incentive structure. If USCIS can generate more revenue from premium fees, there's less institutional pressure to fix the underlying processing delays that make premium processing necessary. This isn't speculation. Multiple immigration attorneys have documented cases where USCIS appears to prioritize premium processing cases so heavily that standard processing cases sit untouched for months beyond normal processing times. One immigration attorney in California documented I-765 cases filed in June 2025 that still hadn't been touched by February 2026, while premium processing cases filed in January 2026 were approved within 15 days. That's not a processing backlog problem. That's a deliberate resource allocation choice that financially penalizes applicants who cannot afford premium fees. The legal challenges to this fee structure are already forming. Several immigration law organizations are preparing administrative challenges, arguing that USCIS violated the Administrative Procedure Act by not providing adequate notice and comment opportunity before implementing major fee increases. The APA requires federal agencies to publish proposed rules, accept public comments, and consider those comments before finalizing rules. USCIS published the fee increase in the Federal Register, but the comment period was minimal, and the implementation timeline didn't allow meaningful public input to influence the final decision. That procedural shortcut might be legally vulnerable. If a court determines USCIS violated APA requirements, the fee increase could be temporarily blocked or permanently invalidated. But legal challenges take time, months or years. Applicants facing deadlines in weeks cannot wait for litigation outcomes. So what does this mean for you right now? If you're planning to file any application that offers premium processing, you need to budget for the new, higher fees immediately. The March 1st effective date means any application postmarked on or after that date will be subject to the new fee schedule. If you already filed an application before March 1st but haven't received a decision yet, monitor your case status carefully. If USCIS sends a request for evidence or a notice demanding additional fees, consult with an immigration attorney immediately. Do not automatically pay additional fees without understanding your legal rights. If the additional fee request seems improper for a case filed under the old fee schedule, you may have grounds to challenge it. But you need documentation. Save your original filing receipts, your payment confirmations, your postmark dates, everything that proves when you filed and what fees you paid. If you're considering premium processing solely because standard processing times have become unreasonably long, document that reasoning. Note the posted processing times on the USCIS website. Note how those times have changed over recent months. Note how your specific situation requires faster processing. That documentation could become important if class action lawsuits or advocacy campaigns challenge USCIS's handling of processing times and premium fee structures. For employers sponsoring workers, this fee increase affects your immigration budgets significantly. An H-1B petition with premium processing now costs $2,805 for the premium fee alone, plus the base I-129 filing fee, plus any additional fees for dependents or concurrent filings. That's a substantial cost per employee. Multiply that across multiple hires, and you're looking at tens of thousands in additional immigration expenses this year compared to last year. Some employers will absorb those costs. Others will pass them to employees or reduce their international hiring. Either outcome has real consequences for immigration patterns and workforce composition. For individual applicants, especially those applying for work permits or green cards independently, these fees can be devastating. A $1,500 premium processing fee for an I-765 work permit is more than many applicants earn in a month. Forcing someone to choose between premium processing fees and basic living expenses creates impossible situations. Pay the fee and skip rent, or skip the fee and watch your job opportunity disappear while your application sits in the processing queue. That's not a functioning immigration system. That's a system that discriminates based on wealth. The political context matters here too. This fee increase comes during a period of intense debate about immigration policy overall. Some see USCIS fee increases as appropriate cost recovery. Others see them as deliberate barriers designed to reduce immigration through financial discouragement rather than legal restrictions. The truth probably sits somewhere in between. USCIS does face real operational costs, but the agency also has a responsibility to maintain processing efficiency at the standard fee level, not allow backlogs to grow so severe that premium processing becomes functionally mandatory. The demand for answers from experts isn't just about the fees themselves. It's about accountability. USCIS operates with significant autonomy over its fee structures, but that autonomy should come with transparency and procedural fairness. When the agency implements major fee increases with minimal notice, minimal public input, and minimal clear guidance on implementation details, It undermines trust in the system. Immigration attorneys are demanding clear answers to straightforward questions. Will pending applications be grandfathered? Will fee waivers be available, and under what criteria? Will USCIS commit to improving standard processing times now that premium fees have increased? These aren't unreasonable demands. They're basic accountability measures that any federal agency should provide when implementing policies that affect hundreds of thousands of people and billions in economic activity. As of this recording, USCIS has not provided those answers. The agency issued the fee increase announcement and moved on to implementation without addressing the practical questions applicants and attorneys immediately raised. That silence is telling. It suggests USCIS either hasn't thought through the implementation details or has decided not to clarify them publicly because the answers would invite criticism. Either way, applicants are left navigating uncertainty, and in immigration matters, uncertainty often means delays, denials, or missed opportunities. So here's what you need to do right now. If you have any pending applications, check your receipt notices and filing dates. Document everything about when you filed and what fees you paid. If you're planning to file new applications, budget for the new premium processing fees, even if you're not sure you'll use premium processing. Having the option is better than needing it and not being able to afford it. If you're working with an immigration attorney, ask them specifically about the fee increase and how it affects your case timeline and budget. Good attorneys are already advising their clients on this. If your attorney hasn't mentioned it, that's a red flag. If you cannot afford the premium processing fees but need faster processing because of job deadlines or other time-sensitive circumstances, document that situation clearly. Write a detailed letter explaining your financial situation and why standard processing times would cause you significant hardship. That documentation might not speed up your case. USCIS is not required to prioritize cases based on hardship when premium processing is available. But if future legal challenges or policy reforms address this issue, having documentation of how the fee structure harmed you could be important. For employers, review your immigration budgets now. The fee increase might seem small on a per-case basis, but it adds up quickly across multiple employees and multiple years. Consider whether your company can commit to covering premium processing fees as a standard benefit for sponsored employees. That commitment can make your company more attractive to international talent and reduces the financial burden on workers who are already dealing with visa restrictions and uncertainty. For advocacy organizations and legal clinics, this fee increase highlights the need for coordinated response systems. Individual applicants challenging fee increases or processing delays have limited leverage. But coordinated advocacy campaigns, class action litigation, and organized public comment campaigns can create real pressure for policy changes. The immigration law community needs to maintain focus on this issue beyond the initial announcement. USCIS will hope that attention fades and implementation proceeds quietly. Don't let that happen. If this fee increase affects you or people you care about, use the feedback mechanisms available. File formal comments if USCIS opens additional comment periods. Contact your congressional representatives. Support advocacy organizations that challenge these policies. Individual actions feel small, but immigration policy changes often result from accumulated pressure over time, not single dramatic moments. The USCIS premium processing fee increase is now reality. The March 1st implementation date has passed. Applicants are already paying the higher fee, but the questions experts are demanding answers to remain unresolved. How will pending applications be handled? What fee waiver options exist? What is USCIS doing to address the root cause? Processing delays that make premium processing functionally mandatory. Those questions deserve answers. Clear, public, documented answers that applicants can rely on when making decisions about their immigration cases and their financial futures. As the March 2026 processing period continues, more details will emerge about what USCIS hoped to achieve with this fee increase. Whether it's purely revenue generation, processing efficiency improvements, or subtle immigration restriction through financial barriers. But one thing is already clear. Knowing this information doesn't make you anti-immigration. It makes you smart. It means you're prepared. It means you're protecting your future and your family's future. Share this video with anyone navigating the immigration system. It might save them thousands of dollars and months of delays. Subscribe to USA Immigration Path for more protection. We protect you with real information as the next phase of immigration policy unfolds.